Hazelwood School District versus Kohlmeier. Justice White delivered the opinion of the court. This case concerns the extent to which educators may exercise editorial control over the contents of a high school newspaper produced as part of the school's journalism curriculum. Petitioners are the Hazelwood School District in St. Louis County, Missouri, and various school officials. Respondents are 3 former Hazelwood East students who were staff members of Spectrum, the school newspaper. They contend that school officials violated their First Amendment rights by deleting 2 pages of articles from the May 13, 1983 issue of Spectrum. Spectrum was written and edited by the Journalism II class at Hazelwood East. The newspaper was published every 3 weeks or so during the 1982 and 1983 school year. More than 4,500 copies of the school newspaper were distributed during that year to students, school personnel, and members of the community. The Board of Education allocated funds from its annual budget for the printing of Spectrum. These funds were supplemented by proceeds from sales of the newspaper. The practice at Hazelwood East during the spring of 1983 semester was for journalism teacher to submit page proofs of each Spectrum issue to Principal Reynolds for his review prior to publication. On May 10th, the journalism teacher delivered the proofs of the May 13th edition to Reynolds, who objected to 2 of the articles scheduled to appear in that edition. One of the stories described 3 Hazelwood East students' experiences with pregnancy. The other discussed the impact of divorce on students at the school. Reynolds was concerned that although the pregnancy story used false names to keep the identity of these girls a secret, the pregnant students still might be identifiable from the text. He also believed that the article's references to sexual activity and birth control were inappropriate for some of the younger students at the school. In addition, Reynolds was concerned that the student identified by name in the divorce story had complained that her father wasn't spending enough time with my mom, my sister, and I prior to the divorce, was always out of town on business or out late playing cards with the guys, and always argued about everything with her mother. Reynolds believed that the student's parents should have been given an opportunity to respond to these remarks or to consent to their publication. He was unaware that journalism teacher Emerson had deleted the student's name from the final version of the article. Reynolds believed that there was no time to make the necessary changes to stories before the scheduled press run, and that the newspaper would not appear before the end of the school year if printing were delayed to any significant extent. He concluded that his only options were the circumstances, which were to publish a 4-page newspaper instead of the planned 6-page paper, eliminating the 2 pages on which the offending stories appeared, or to publish no newspaper at all. Accordingly, he directed Emerson to withhold from publication the 2 pages containing the stories on pregnancy and divorce. He informed his superiors of the decision, and they concurred. Students in the public schools do not shed their constitutional rights to freedom of speech or expression at the schoolhouse gate. Which is from the Tinker case. They contend they cannot be punished merely for expressing their personal views on the school premises. Again, this didn't involve punishment, I don't think. Whether in the cafeteria or on the playing field or on the campus during the authorized hours, unless school authorities have reason to believe that such expression will substantially interfere with the work of the school or impinge upon the rights of other students. We have nonetheless recognized that the First Amendment rights of students in public schools are not automatically coextensive with the rights of adults in other settings. So substantially, I feel that the test is being cited here from another case, that the expression substantially interfere with the work of the school or impinge upon the rights of other students. And First Amendment rights of students must be applied in light of the special characteristics of the school environment. A school need not tolerate student speech that is inconsistent with its basic educational mission, even though the government could not censor similar speech outside the school. We thus have recognized that the determination of what matter of speech in the classroom or in school assembly is inappropriate properly rests with the school board rather than the federal courts. It is in this context that respondents' First Amendment claims must be considered. We deal first with the question whether spectrum may appropriately be characterized as a form of public expression. The public schools do not possess all of the attributes of streets, parks, or other traditional public forums that, time out of mind, have been used for purposes of assembly, communicating thoughts between citizens, and discussing public questions. The policy of school officials towards spectrum was reflected in Hazelwood School Board Policy and the Hazelwood East Curriculum Guide. Board policy adopted curriculum in its educational implications in regular classroom activities. The Hazelwood East Curriculum Guide described the Journalism 2 course as a laboratory situation in which the students publish the school newspaper applying skills they have learned in Journalism 1. Journalism 2 was taught by a faculty member during the regular class hours. Students received grades and academic credit for their performance in the course. School officials did not deviate in practice from their policy that production of spectrum was to be part of the educational curriculum and a regular classroom activity. The question whether the First Amendment requires a school to tolerate particular student speech, the question that we address in Tinker, is different from the question whether the First Amendment requires the school affirmatively to promote particular student speech. The former question addressed the educator's ability to silence the student's personal expression that happens to occur on school premises. The latter question concerns educators' authority over school-sponsored publications, theatrical productions, and other expressive activities that student parents and members of the public might reasonably perceive to bear the imprimatur of the school. This is distinguishing from Tinker yet again. The issue, that is. These activities may fairly be characterized as part of the school curriculum, whether or not they occur in the traditional classroom setting, so long as they are supervised by faculty members and designed to impart particular knowledge or skills to student participants and audiences. Educators are entitled to exercise greater control over the second form of student expression to assure that participants learn whatever lessons the activity is designed to teach, that readers or listeners are not exposed to material that may be inappropriate for their level of maturity, and that the views of the individual speaker are not erroneously attributed to the school. Hence, so these are student interests, state and school interests. Hence, a school may, in its capacity as publisher of the school newspaper or producer of a school play, disassociate itself not only from speech that would substantially interfere with its work or impinge upon the rights of other students, but also from the speech, for example, ungrammatically, poorly written, inadequately researched, biased or prejudiced, vulgar, profane, or unsuitable for immature audiences. A school must be able to set standards for student speech that is disseminated under its auspices. Standards that might be higher than those demanded by some newspaper publishers or theatrical producers in the real world, and may refuse to disseminate student speech that does not meet the standards. In addition, the school must be able to take into account the emotional maturity of the intended audience in determining whether to disseminate student speech on potentially sensitive topics, which might range from the existence of Santa Claus in an elementary school setting to the particulars of teenage sexual activity in a high school setting. A school must also retain the authority to refuse to sponsor student speech that might reasonably be perceived to advocate drug or alcohol use, irresponsible sex, or conduct otherwise inconsistent with the shared values of a civilized social order, or to associate the school with any position other than neutrality on matters of political controversy. Accordingly, we conclude that the standard articulated in Tinker for determining when a school may punish students' expression may not also be the standard for determining when a school may refuse to lend its name and resources to the dissemination of student expression. Instead, we hold that educators do not offend the First Amendment by exercising editorial control over the style and content of student speech in this is their holding, in school-sponsored expressive activities so long as their actions are reasonably related to a legitimate pedagogical concerns. And so that holding includes the test for analysis. This standard is consistent with our oft-expressed view that the education of the nation's youth is primarily the responsibility of parents, teachers, and state and local officials, and not federal judges. It is only when a decision to censor a school-sponsored publication, theatrical production, or other vehicle of student expression has no valid educational purpose that the First Amendment is so directly and sharply implicated as to require judicial intervention to public students' constitutional rights. So that would be another way of formulating a test for analyzing First Amendment rights of students. We conclude that Principal Reynolds acted reasonably in requiring the deletion of the May 13th issue of Spectrum of the pregnancy article, the divorce article, and the remaining articles that were to appear on the same pages of the newspaper. The initial paragraph of the pregnancy article declared that all names had been changed to keep the identity of the girls secret. The principal concluded that the students' anonymity was not adequately protected. However, given the other identifying information in the article and the small number of pregnant students at the school, in addition, he could reasonably have been concerned that the article was not sufficiently sensitive to the privacy interests of the students' boyfriends and parents who were discussed in the article, but who were given no opportunity to consent to the publication or to offer a response. The article did not contain graphic accounts of sexual activity. The girls did not comment in the article, however, concerning their sexual histories and their use or non-use of birth control. It was not unreasonable for the principal to have concluded that such frank talk was inappropriate in a school-sponsored publication distributed to 14-year-old freshmen and presumably taken home and read by the students' even younger brothers and sisters. The student who was quoted by name in the version of the divorce article seen by Principal Reynolds made comments sharply critical of her father. The principal could reasonably have concluded that an individual publicly identified an inattentive parent, indeed as one who chose playing cards with the guys over home and family, was entitled to an opportunity to defend himself as a matter of journalistic fairness. In sum, we cannot reject as unreasonable Principal Reynolds' conclusion that neither the pregnancy article nor the divorce article was suitable for publication in Spectrum. And since there's time, Justice Brennan, with whom Justice Marshall and Justice Blackmun joined dissenting. When young men and women of Hazelwood East High School registered for journalism too, they expected a civics lesson. The school board itself affirmatively guaranteed the students of journalism to an atmosphere conducive to fostering such an appreciation and exercising the full panoply of rights associated with the free student press. School-sponsored student publications, it vowed, will not restrict free expression or diverse viewpoints within the rules of responsible journalism. This case arose when the Hazelwood East administration breached its own promise, dashing its students' expectations. The school, I guess that's a contractual law. The school principal, without prior consultation or explanation, excised 6 articles comprising 2 full pages of the May 13, 1983 issue of Spectrum. He did so not because any of the articles would materially substantially interfere with the requirements of appropriate discipline, but simply because he considered 2 of the 6 inappropriate, personal, sensitive, and unsuitable for student consumption. In my view, the principal broke more than just a promise. He violated the First Amendment's prohibition against censorship of any student expression that either disrupts classwork nor evades the rights of others, and against any censorship that is not narrowly tailored to serve its purpose. Since the censorship served no legitimate pedagogical purpose, it cannot by any stretch of the imagination have been designed to prevent material disruption of classwork, nor did the censorship fall within the category that Tinker described as necessary to prevent student expression from invading the rights of others. If that term is to have any content, it must be limited to rights that are protected by law. Any yardstick less exacting than that could result in school officials curtailing speech at the slightest fear of disturbance, a prospect that would be completely at odds with this court's pronouncement that the undifferentiated fear or apprehension of disturbance is not enough, even in the public school context, to overcome the right to freedom of expression, which was quoted from the Tinker case. And as the Court of Appeals correctly reasoned, whatever journalistic impropriety these articles may have contained, they could not conceivably be tortious, much less criminal. Finally, even if the majority were correct that the principal could constitutionally have censored the objectionable material, I would emphatically object to the brutal manner in which he did so, where the separation of legitimate from illegitimate speech calls for more sensitive tools. The principal used a paper shredder. He objected to some material in 2 articles, but excised 6 entire articles. He did not so much as inquire into obvious alternatives such as precise deletions or additions, one of which had already been made, rearranging the layout or delaying publication. Such unthinking contempt for individual rights is intolerable from any state official. It is particularly insidious from one to whom the public entrusts the task of inculcating it in its youth an appreciation for cherished democratic liberties that our Constitution guarantees. The young men and women of Hazelwood East expected a civics lesson, but not the one the court teaches them today. My personal opinion is I do not understand how 3 Supreme Court justices do not find that the principal in allowing the publication would not be answerable to a civil tort liability. That's my own personal response to this case.